share screens here. All right, so this record session is now being recorded, and share screen, and I click on the screen here. We'll get my my screen up live for you. And
good, Steve. I can see it.
You can see it. Okay, I haven't really got it running yet, but we'll get it started. There we go. And I think there we are. Okay, so you can see it. Listen, I'm going to say the same things that I did yesterday. And I want to give you an apology also, sort of. While I'm talking, I don't always see that somebody's put a question or a comment in the little box there. You're welcome to do that. And if I don't see it right at the moment that you put it up there because I'm babbling away, I will come back to it. So sometimes it sort of gets out of flow. I see a question from 5 minutes earlier. I'll try to deal with it right away. I do encourage you to, there are some people right now that are off of mute. So Beverly, for example, I see you're off of mute. If you will mute, that way you can talk and your phone can ring and things can happen in the background and you can sneeze and we won't get kind of reverb happening. But I do encourage you that if you have a question, instead of using that dialog box to type your question in, just take yourself off of mute and say, hey, Steve, it's me. Yash, I'm here and I want to ask a question about that, and just jump in and interrupt me. And I have my volume turned down really low on my computer so that I don't create a loop because I'm using a microphone, professional microphone system up here. So you might have to speak up or whatever just to get my attention. I'm not turned off entirely on my volume, but will be quiet. Please interrupt me. Try to make it interactive so that you can ask questions. And again, if you don't have your mute turned on all the time, so for example, Catherine, I noticed that you're not muted. There is a little button that you can click by looking at the bottom of your screen and clicking your mute button. That's great. And again, that's just to stop some sort of background noise and cycling. But please unmute yourself if you want to talk and jump in there and interrupt me. I promised yesterday that we would get finish early today, and that's because we have pretty much the same people on for our second session of the CPC as we did for the first. And there's a couple things at the beginning about CPC and so on that are kind of redundant. So I'm not going to repeat most of that, or at least I'm going to bomb through it really fast today so that I'm not repeating myself. But I want to congratulate you on making your decision to pursue your certified personnel consultant designation. It is a sign that you have made a commitment to your profession, to be professional, to understand what is required of you by law and in normal ethical practices and best practices. It is something that you should be proud of. And it is something that maybe about 5 or 10% of the people who enter the industry at this point in time pursue. At least lots of people kind of wait until they get through their first year or two. If you're in your first couple of years, then really congratulations. That makes you very special that you've made a commitment to your profession. There's going to be these sessions coming up in the near future. Today is legal aspects of recruitment. Yesterday was staffing. There's also sessions on health and safety, recruitment, and business ethics practices. And again, at the end of this, you will be asked to perform the challenge exam in order to earn your CPC. I've said it several times yesterday. I'll say it again today. Don't get bunged up in trying to memorize specific details about legislation. Every province has slight differences in their legislation, and it's really important to understand what the legislation is intended to cover, the kinds of things it covers, the big principles around the legislation, and know that you can always go and look up the details about the number of days or weeks or specific terminology in your province. It's more important that you understand what it's about and why it's there and where to find it than to memorize some of the details. I've been doing this for well over 30 years, and I don't memorize anything. Today, we're just going to remind you that you're allowed to be on this session because you work for a member, work for or own or operate or manager of a member company. Once you've achieved your CPC, then you can carry that designation with you, regardless of whether you're with that company or not. Every company that is a member of ACSESS is committed to the ACSESS Code of Ethics and Standards. And today, we're going to be dealing with human rights legislation. We're going to identify and explain how that human rights legislation applies to us in the recruitment and staffing services industry. We're going to talk about the concepts of diversity, equity, and employment equity. And we're going to try to figure, and we're going to talk a little bit about privacy legislation, PIPEDA legislation, and how it differs federally and provincially, and how it applies to us in the staffing services industry. And of course, we're going to talk about how we can use some of these concepts, legal principles, and ethical principles to apply them to our business so that we can be great recruiters, great business operators. We can differentiate ourselves in the marketplace. We want to be profitable. We want to be have a sustained, recurring, profitable business. We want to have low turnover and high retention of our high quality employees in our business, and really pursuing human rights, diversity, equity, and privacy are great ways to send a message to your customer, your candidates, and your coworkers that you're committed to professionalism and that you're the right company to work with and for. So again, in the big picture today, we're going to look at human rights legislation, employment equity legislation. We're going to discuss the principles of diversity and equality, and we're going to talk about privacy. That's that PIPEDA thing down in the bottom right-hand corner. So first off, human rights. So human rights describes how we instinctively expect to be treated and what all people are entitled to. And it describes how we really are expected to treat others with dignity, respect, and equality. Now, remember, equality doesn't mean the same. Equality means equality of opportunity, equality of in process. All people, and we're going to see through a concept today called bona fide occupational requirements and how we can accommodate people, that through reasonable accommodation, we don't always treat people exactly the same, but we give them the same opportunity through bona fide occupational or through accommodation. So yesterday I talked about the various types of laws. We talked about the Charter of Rights and Freedoms being the law of laws. And we talked about how that high level law of laws then helped give guidance to our legislators when they're creating statute law. We talked about my brain has stopped. We talked about how laws are created in the courts, and we talked about contract law. And we also talked about how the Charter of Rights and Freedoms and how the Canadian Charter defines who federally or provincially is responsible for different legislation. So we have got the Charter of Rights and Freedoms that kind of lays out the kind of high level for human rights in Canada and equality and privacy in Canada. And then we have federal legislation that applies to federally regulated industries. And we've got federal legislation that applies to federal government employees. And then we have got provincial legislation for the rest of us. So we're going to see that we've got human rights, the Human Rights Act, the Canadian Human Rights Act, which applies to federal government employees and federal run special agencies like our federal prisons and like the CRTC and other federally run or regulated businesses. And then also it applies to federal industries like radio and television, banking, and so on. And so this Canadian Human Rights Act is the law, the statute that applies to all of those people and industries. And then we've got the Charter, which is the Charter of Rights and Freedoms, which is the high level, which kind of helps us define what it is that we're trying to cover. And then we've got the federal, various provincial human rights codes or laws in each province. So in this example, the Ontario Human Rights Code, which applies to the provincially regulated businesses. So we're going to use today again, and I apologize for those people from British Columbia and Alberta who are on the line. But they're all fundamentally the same because they're driven by the Charter of Rights and Freedoms, and they're modeled after the federal human rights code. And so each province has their own set of laws, but they pretty much cover the same 11 aspects of prohibited grounds. And they pretty much deal with it in almost exactly the same way. There's just subtle differences on how you create, say, for example, how you create an appeal or how you file a claim or what body is responsible for the claim or what the process is going to be to cover a claim. And so each province has their own unique human rights legislation, but they're all fundamentally the same. And again, I can't deal with all the provinces and territories exactly at the same time. So we typically deal with Ontario and use examples from other provinces, as I will today, to kind of give you examples how it might change a little bit and who looks after these types of things. So in our world, when it comes to human rights, we think about employment practices, and advertising practices tend to cover things like recruitment advertising, how we get and handle referrals, how we promote or demote people, who we give training to and how we provide that training, how we set our wages. It deals with things like our application forms, our online applications and application procedures. Human rights deals with the types of questions that we're allowed to ask in interviews, and the types of answers we're allowed to use in order to evaluate people. So sometimes people in an interview aren't asked a particular question that is prohibited, but sometimes the candidate provides us an answer. They offer up some information that takes us into a prohibited ground. And, so are we allowed, now that they've offered that information, if it's in a prohibited area, we're not allowed to use that information in our decision in hiring that person. There's some exceptions, and we're going to talk about some of those exceptions today and with the terminology we use around that. It covers things like apprenticeships, who's going to get training and get promoted and become journeymen. It talks about transfers of employment and really pretty much any matters that deal with the recruitment, advertising, selection, promotion, pay of employees. So discrimination in a workplace, discrimination is really defined as an action. There's a lot of different definitions of discrimination, by the way. But generally, discrimination is defined as an action or a decision that treats a person or a group of people negatively for reasons such as their race or their age or their disability. And these reasons are known as grounds of discrimination. So sometimes, like, for example, let's try to be topical today. We've heard people talk about how the people who are unvaccinated are discriminated against. And so the unvaccinated folks say that you're segregating society, you're separating society, you're pitting society against each other, and you're discriminating against the unvaccinated. Well, interestingly enough, being vaccinated or unvaccinated, your decision to be vaccinated or unvaccinated are not necessarily covered under the Charter or under the Human Rights Act, because these are decisions of behavior. Now, if one could make the argument that their decision to become unvaccinated, remain unvaccinated, was based upon a health issue. Then now we've ventured into one of the grounds of discrimination, which has to do with disability or health. And one might say that it violates our privacy, that the Charter of Rights and Freedoms allows us to have privacy, and especially around health privacy. So one might argue that having to disclose our status could enter into a violation of our right to privacy. Or one might argue that for religious reasons, I don't get vaccinated, or someone doesn't get vaccinated. And so they could argue that discriminating against a person based upon their religious beliefs is a violation on prohibited grounds and in the Charter. And so the notion itself that someone is vaccinated or unvaccinated is a violation of human rights, or it's a violation of a charter right, in itself doesn't stand very well, which is why some of governments have been able to institute certain rules, and why some things have already been challenged in courts, and why there are reasons, like medical reasons, that people can be waive the need for them to be vaccinated. So this gets very complicated because the law really only deals with certain aspects of prohibited grounds, not all aspects of prohibited grounds. So you can't say to someone, geez, that person is smarter than me and you didn't hire me. That's discrimination. You're discriminating based upon intelligence. Unless that difference in intelligence is based upon a disability, then that's not a prohibited ground. And so a lot of times we hear people talking about there being discrimination when in fact discrimination based upon the defined categories, the 11 defined categories of race, national or ethnic origin, color, religion, age, sex, sexual orientation, marital status, family status, disability, or a conviction, a previous conviction for which the person has been granted a pardon or a record suspension. So a pardon or record suspension means that legally that doesn't exist anymore. Now, you can select people who are free and clear of criminal convictions or not hire a person who does have a criminal background if somehow there's a bona fide occupational requirement. For example, you're put in a position of trust. So, it would be safe to say that if we're going to have people look after children, that we could say it's a bona fide occupational requirement that you be free and clear of any criminal convictions, particularly maybe criminal convictions for endangering people or for pedophilia or for some other child against a person, that those would be reasonable grounds for selecting a person or not selecting a person. Now, once we get to the area of pardon, that means that actual conviction legally doesn't exist anymore. And of course, there's some things that people will never be pardoned for. So these are the 11 grounds. The Charter of Rights and Freedoms kind of lays out the high and our right to privacy, lays out the high level. Then the federal government has written their Canadian Human Rights Act that has these 11 areas, and each province has written very similar provincially industries in their province. Again, I've just received a notice that the internet is unstable. So I'm hoping that you can hear me. And if you can't, I don't know. If you can't hear me, can I hear you? I think everything's okay. So it's interesting too how some of these changes to legislation in common law, we talked yesterday about common law, how some of these things evolve and come into place. So for example, Originally, the Charter of Rights and Freedoms and the Canadian Human Rights Act did not have sexual orientation. The rights of LGBTI persons were not written into the legislation. So this is an interesting story about how things come to be. In 1995, in this case, Egan versus Canada, the Supreme Court of Canada held that although sexual orientation was at the time not listed as one of the areas for grounds for discrimination in section 15.1 of the charter. So section 15.1 is kind of lays out the high level of what should be covered, prohibited, what areas should be prohibited, that we can't discriminate against people. And so when the legislation was written, the Canadian Human Rights Act was written, that it prohibited it violated section 15.1 of the charter because it constitutes that LGBTI rights were the equivalent grounds of other forms of discrimination. And so in a case called Friend versus Alberta, the court held that the provincial human rights legislation that left out the grounds for sexual orientation violated the charter. So remember, the charter, it's not important that you remember these cases. What's important is you remember the process. The Charter of Rights and Freedoms was written. The Alberta provincial legislation was then written thinking that it was adhering to the charter. They didn't list sexual orientation as one of the areas that were prohibited with respect to discrimination. Sometime later on in 1995 and in 1998, there were court cases at the Supreme Court and in the Alberta courts that said, hey, this is the kind of thing they meant, even though they didn't anticipate the language that would be used to describe same-sex marriage and or other forms of sexual orientation. This is the kind of stuff that they really meant to be covered. So the courts created a common law or precedents in the court that if other similar cases with the same set of circumstances came up, that this would have already been decided. And then in order to make it seem really clear, in 2000, the federal government in Parliament passed Bill C-23, which then went in and gave same-sex couples the same social and tax benefits as heterosexual couples that existed in common law relationships. So, kind of what happened was a bunch of rights were given with respect to heterosexual couples, with respect to their rights to social benefits. And a friend of mine, Doug Elliott, argued a case concerning CPP, Canada Pension Plan, death benefits, and won based upon these same principles. And then it got written into the law later on and was specifically defined in statute. So in Canada Pension Plan, when your spouse passes away, of course, they've built up this Canada Pension Plan with all these benefits in it. And I believe the number is $5,000 these days. It might be more. But your surviving spouse automatically gets a one-time payment because there's obviously some money left in the Canada Pension Plan that's been put in there. And so the surviving spouse receives a one-time payment. And for years, same-sex partners were not able to collect the survivor benefit that came from Canada Pension Plan. So Doug Elliott went to the Supreme Court, made the argument, won the argument that basically same-sex partners are very similar to common law partners. Well, like, why would it be any different? And then eventually it gets written into the legislation that that this becomes law in the human rights laws. And so, the Civil Marriage Act in 2005 marked a milestone in sexual orientation, giving equal rights by allowing same-sex couples to be married anywhere in Canada. So basically, if there were any provinces left over that said, hey, in common law or in a church or at City Hall, if they're not allowing people of same sex to get married. So what happens is the Charter of Rights and Freedoms up here sets out the standards. People interpret the standards differently. Governments implement laws, human rights laws. They maybe miss out on some stuff. People go to court and they fight their argument that whether it's LGBTI or whether it's same-sex common law, that they say, hey, they go to court and they argue that this is the same. They say, hey, yeah, you're right under common law. So they set now common laws, precedent, standards, and then governments come and follow up behind it and say, okay, let's write this right into the statute so that people can understand this in written law, not just in case law and in common law. And it becomes easier for us to understand. So there's this notion in discrimination called adverse effect discrimination. Now, all discrimination is bad, but adverse effect discrimination is not bad discrimination. It's kind of like unintentional discrimination that no one should have, probably wouldn't have envisioned that it was going to happen. And so they come along and they create a policy or practice that is unintentionally singles out a person or a small group of people or a particular group of people and results in unequal treatment. So this type of unintentional discrimination is called adverse effect discrimination. And so let's try to think about what would be an adverse effect discrimination. So requiring employees to wear a promotional uniform that conflicts with a person's religious clothing. So let's say, a person during their religion needs to wear a symbol or a head covering or something, or body facial coverings in their religion, and then the chicken company comes along and says, no, you can't wear that. You have to wear our chicken suit. You can't wear that. You have to wear our uniform, and you can't wear that head covering or facial covering or that symbol of your religion. And we then realize that the policy was written to maybe lower employees' clothing costs, to provide clean uniforms every day that they could wear to work, that were safer, that didn't have things hanging off the side that could get caught in machinery. They had the right pockets for the doctors to put their stethoscope, or the chicken uniform that got covered in grease was left at work, and a clean uniform was provided every day. So it was for sanitary reasons, and it was for marketing and advertising. And so, the company sets out, you must wear a uniform, not with any specific idea that this might interfere with a person's religion. So establishing work schedules, such as uniform rotations, like, you do 2 weeks on days, 2 weeks on afternoons, 2 weeks on evenings. You alternate 4 days a week, 3 days a week, 4 days a week, 3 days a week. And this is a standard rotating schedule. It's supposed to be designed to make it predictable and make it fair, and for people to figure out in 6 months from now at Christmas, am I scheduled to work or not? All this kind of stuff. These things might be perfectly fine, except for from an adverse effect, we might find that a person has a religion that they can't work after dark on Fridays, after sundown on Fridays. They might find that they've got a religious holiday on a particular day that's not the same religious holidays that we practice for Christmas Day and Thanksgiving and Eat Good Friday, for example. So having these rotating schedules might have had a lot of great benefits to them, but they could adversely affect someone not taking into consideration, anticipating that someone might have a religion. Standardizing office furniture my company, we have standard computers, standard chairs, standard desks, standard things that we'll reimburse people for if they want to buy them for our homes, and it may turn out that a person with a disability needs a bigger screen or needs a different kind of chair or needs a desk that's a different height. And so although these might be really great business decisions to try to keep costs down and to be fair to everyone, that some person didn't get a better chair than someone else because they're favored for some reason or discriminated against for some reason, but it may not work out in an adverse. So there's other things, that could affect gender, age, family status that were not intended. Now, really bad discrimination is systemic discrimination. And we hear the word systemic discrimination used and kicked around all the time on TV and radio and the news when people make accusations against the RCMP's systemic discrimination against women and a culture that is systemically discriminatory towards certain groups of people. And so the systemic discrimination, and by the way, it is pronounced systemic. So we know that some people on radio and television call it systematic. It's not systematic, it's systemic. When discrimination happens because there's a business practice or a workplace policy or a government program or something is called systemic, because the discrimination is not limited to this single adverse event, but it regularly imposes this discrimination upon a specific or a large group of people. By the way, I think I might have mentioned to the other day, I have a disabled 27-year-old daughter in the house, and every once in a while she stands at the bottom of the stairs and calls out to me. So if you hear some background noise, I'm not a mean dad. She's got a caregiver with her, and I apologize if there's sounds like I'm abusing someone. I'm not. So systemic discrimination is often referred, if it's not corrected and identified, is often referred to a Human Rights Commission because, if companies knowingly and willingly have systemic discrimination in place, it seems to send a symbol that they either don't understand what systemic discrimination is or they're perfectly fine with the fact that it exists. And so the normal way to do things in the workplace may have a negative impact on those who are racialized or disabled or something. And so those things are often referred to the Human Rights Commission. So examples of systemic discrimination are things like criminal background checks on people that aren't responsible for dealing with money or finances or proprietary information or the safety of other individuals. And so if you're laying sod and you're hiring people to lay sod and they follow the truck and, the person throws the sod off the back of the truck and they grab it and roll it out and push it down on the ground, I don't know if having a great criminal background check or a credit check on that person really has anything to do with the job whatsoever. And so that would be discriminating against people because of their financial status, or maybe their financial status might come from some other area that financial status is not a protected area. But background checks for criminal background checks and credit checks are often tied to things like age and, status and so on. Recruitment practices such as favoring or limiting to word of mouth. So if you only hire people that are referred to you by word of mouth from your existing employees, it's pretty much saying, well, I want more people just like them. And so if you happen to be a family business of a particular religion, and then you hire your family friends who happen to be of the same religion, and then they referred their nieces and nephews, sons and daughters, brothers and sisters, and we hire them, we've set up a hiring system that really eliminates a vast majority of the population that may have other racial backgrounds, colors of skin, religions, and so on. So steering of applicants to certain jobs or assignments based upon their race or gender. So if we always said to the women, hey, you apply for the nurse job, and always said to the men, you apply for the doctor job, that would be gender discrimination. And so having some sort of, even if it's unwritten sort of mechanism in place that people just do that is systemic discrimination. Historical segregation in occupations or industries. So segregating people, there was a lot of articles recently in the newspaper about truckers, and a large number of Punjabi truckers in the trucking industry in Canada. And so if we only hired Punjabis, people with Punjabi heritage, into trucking jobs, that would be discriminatory. Or if we didn't hire people, if we hired people because they were Punjabi, or we didn't hire people because they were not, that would be systemic discrimination. So that could come from recruitment referral practices. That could come from us streaming people based upon systemic discriminatory beliefs. And we're going to talk a little bit later on in today's session about how organizations can identify these things and try to rectify some of those practices. Customer preferences. If you've got a customer that says, I won't deal with a person like this, only send me people like that, that would be accepting those orders and allowing customers to drive your behaviors would be considered systemic discrimination. So I've got other things here, using big data background algorithms that sort through resumes that only look for certain words might be systemically discriminating against people. Some personality tests that people that don't speak English well or don't understand some of the questions because they might have to deal with preferences or things, certainly would be systemically discriminatory. Mandatory religious practices, English only rules, these are all systemic discrimination. Boy, I got more on the list. Age-based limits for things like you can't get your benefits unless you're over a certain age or under a particular age. Now, the courts have put into place some rules about long-term disability and some other things over age 65. A lot of those things have been removed. For example, you can't, you can't force a person to retire at age 65 because that would be discriminatory. But insurance companies have made a pretty good argument that you can't buy life insurance through your company after age 65. So you can't say, oh, geez, I'm getting near the end of my life. I think I'm going to go get a couple $1 million worth of life insurance. So there are certain things that are allowed and certain things that are not. And they look to see if it's systemically discriminatory or if there's a good reason for it. Mandatory retirement, just waive that. You can read the rest of these. Here's an interesting one. Light duty policies for only work-related injuries. So we have these things called modified work programs where a person gets injured at work and they go on workers' compensation, they receive benefits, and then they start to recover and they can now use their hands, but they had a wrist injury or hand injury, and they can now start to use their hands, but they can't do high dexterity work for long periods of time. They need to do more, large motor muscle type of activities. And so we modify work to people. So maybe they don't do typing, but they might do some lifting. But what happens if a person didn't injure themselves at work? It's just from old age, or it's just from some other injury, or it's just from some other disability. So these start to fall into the areas of age and disability coverages, and they don't have to be tied just to work-related injuries. This could be considered systemic discrimination. Pre-employment medical inquiries. So, there are certain industries and jobs that do have pre-employment medical requirements. And, for example, I think that you need to go and get a tuberculosis test before you can become a nurse in many hospitals. Who would want to have somebody with tuberculosis working alongside a patient that's got vulnerable comorbidities? And so there's certain types of employment and certain types of pre-employment medical tests that have been approved by the courts. Many of them have been challenged. Things like the presence of marijuana and THC in a person's blood through a medical exam before pre-employment. Pot is legal in Canada, recreationally and medically. and THC remains in a person's bloodstream for up to 30 days or longer. And so if a person smoked pot for medical reasons 2 weeks ago or recreationally last weekend and does not have a substance abuse problem, doesn't come to work under the influence of drugs or alcohol, how could a pre-employment medical inquiry that looked to see if there was the presence of THC in their blood be used legally to discriminate against a person in access to employment? So all of these things are set out with an intent, and sometimes the intent is disingenuous, and that would really be bad. That would be disingenuous systemic discrimination. Sometimes they're set out thinking they have the right intent, but they have the wrong outcomes, and so they become systemic discrimination and they need to be addressed and removed. Sometimes it's adverse discrimination. In other words, it's set out with a good intent, it serves a good purpose, but every once in a while it doesn't fit. So there's the difference between systemic and adverse discrimination. So adverse discrimination is considered to be a good policy that may unwittingly, unknowingly, or unintentionally have an impact on a person or a group of people. However, it's still a good policy. And overhauling that entire policy may require the occasional effort to not overhaul the policy, but to accommodate the individual that it, or the small group of people that it unintentionally or unwittingly affected. So we try to accommodate adverse discrimination, and in doing so, we ask ourselves whether, is this really a good policy? Could we tweak the policy? Could we change the policy? Like, for example, we might say, here's the chair you need to use, you must use. And here's, and then find out that a person with a bad back, that chair doesn't work for them. Or we could say, here's the budget and the supplier for the chairs that we're going to use. And you can buy any chair you want with this budget, as long as it's from the supplier. And if you tick this box because of some disability or medical issue, we can subsidize an increment of $50 or $100 or $500 or whatever the policy might be to help you to buy an upgraded chair to deal with your medical issue. So there would be a policy that was looked at. We started off saying everybody gets chair A, and then we think it's a good policy because it's a good chair. It's good for ergonomics. It's good for fairness. It's good for budget. But we might revisit the policy and say, hey, as long as we come in budget and we're fair about how we procure these things, and we give people equal access, and we've got an accommodation for the people that it adversely affects, then we can slightly modify the policy and also deal with the adverse effect discrimination. So there's an example. I just made it up on the spot. I think it's an okay one. Systemic discrimination is not a good policy. And so when we see and understand that it systemically discriminates, we say, this policy is no good. Let's change it. So once we get into systemic discrimination, then we start to realize, hey, we might have to accommodate a person because we didn't intend for this to happen to them. And so if it affects them under one of the 11 areas of prohibited grounds, we say, okay, how do we accommodate person? And very often, and particularly in a more legal setting, we use the word reasonable accommodation, reasonable in front of the word accommodation, not just accommodate, because accommodating a person doesn't necessarily have any limits to it. And so if a person says, hey, look at I don't speak English, but this is for an English teaching job, could we reasonably accommodate this person? I don't think so. Could we accommodate this person? Yeah, we could say, yeah, okay, we'll give you 10 years to learn to speak English, and we'll send you on $1 million worth of courses. And once you've, graduated from university, you can come back into the classroom. But in the meantime, we're going to continue to pay your salary. That would be unreasonable amount of accommodation. So we add the word reasonable in front of the word accommodation because we're not just going to accommodate everybody all the time. And So we take a look at accommodations, and they can be religious accommodations, i.e., give that person that day off. And, maybe they work on Christmas Day and they don't work on their religious holiday. They don't work on, Rosh Hashanah. I don't know. So the decision can be made to reasonably accommodate person religiously or academically. So we take it other things like job advertisements. We might be living and working in an area that's got 5%, 3% of the population is Chinese, and we got 1,000 employees. We don't have one single Chinese person, and we might have customers that come into the customer service area that only speak Chinese. Why wouldn't we just reasonably accommodate Chinese people by running advertisements in Chinese to hire people that might speak Mandarin or Cantonese? And now we can accommodate our customers. We can reasonably accommodate our customers. We can reasonably accommodate the part of the world that we never attracted before when we wrote our ads only in English. So these are reasonable accommodations. Some people might say, that's just smart business, Steve. Well, guess what? When you attract, retain, employ, and serve customers that are of fit into all areas of prohibited grounds, so people of all genders, people of all ages, people of all religions, people of all ethnic backgrounds and colors of their skin, people with all abilities and disabilities. When we employ people like that, and when we serve customers like that, and we develop a business that does that, we're likely to be a heck of a lot more profitable and a heck of a lot more marketable. And we're likely to retain our good employees that will continue to want to work for us instead of go work someplace else where they can be accommodated. And so good business decisions are often the right business decisions from a human rights perspective. And I would say they always are. So apprenticeship programs that are not designed for older workers. If companies only allowed like recent graduates who are ages like 20 to 30 years old to enter apprenticeship programs, but they never allowed a 50-year-old to enter an apprenticeship program when the 50-year-old really wanted to work for 20 more years, it doesn't make any sense. That we would discriminate against the 50-year-old based upon age when who knows, the 20-year-old may not work for us for 20 years anyways. We know, people are changing jobs X number of times in their lives. So we might be training all the 20 to 30-year-olds and only keeping them around for 5 or 6 or 7 years anyways. And if we're not giving that opportunity of apprenticeship to the 50-year-old or to the 60-year-old, then, we're causing harm to our company and we're systemically discriminating. So we can introduce software inside our company and keyboards. And by the way, I'm just watching my phone. I apologize. Too much personal information, but my wife fell and hurt her ankle, and she's in the emergency right now. And I might have to stop to make arrangements for her to get picked up. She's okay. Not her ankle, her knee. That phone ringing over there made me think that might be it. So, installing software, for people that have got more accommodations in the software. We know that on our iPhones that you can install on your iPhone various features that will accommodate people with that have got point and click issues or with visibility vision issues, or we can do voice to text so that people with hearing problems can use their phone. So, iPhone's a perfect example of how we can install software or configure it in such a way to reasonably accommodate people without incurring a whole bunch of additional costs. So let's take a look at, if I can click this. Sometimes we don't accommodate people. And this is, when I grew up, it was called a bona fide occupational requirement. And we read now, I see a lot more people calling them bona fide occupational qualifications. So BFORs or BFOQs. So a bona fide occupational requirement is when there's something that's the Latin word bona fide means, geez, when I talk about something's bona fide, I use the word bona fide. The Latin words for bona fide means that it is real and that it is justifiable. And so if you've got a real justifiable occupational requirement, that might mean, for example, that if you're going to be an English teacher, that you speak and write English and comprehend English well, and that you've passed English tests and exams. So we've made a bona fide occupational requirement that you can pass the English exam before you're allowed to teach English. And we can't reasonably accommodate a person, except for, by the way, when you want to go work for the federal government, in most jobs, you eventually have to pass a bilingual test. And they reasonably accommodate people very often by giving them 2 or 3 or 4 years to study French and to pass the government's French tests. So there's a bona fide occupational requirement saying you have to be able to be bilingual. And there's a reasonable accommodation, which is giving people 2 or 3 years and they offer the courses for free and so on, to be able to get to that minimum standard. And so there's an issue of a bona fide occupational requirement, and there's an offering of a reasonable accommodation. But giving people forever would not be reasonable. Otherwise, why would you have it as a requirement or a qualification? A bona fide occupational quality is a quality that, when considered in the context, would normally constitute discrimination and would violate human rights, except for, so the terrible example I've given before is that, let's say, for example, you get a job as a customer service representative who gives tours of a heritage jail. And one of the corridors that gets you access to 50% of the jail is a specific maze of 3 foot. I'm making this up, by the way. I'm making these up because I went for a tour of the Toronto jail, and there's actually a little zigzag on the original Toronto jail back in the old days, which is now the Toronto Rehab Center. But in the historical part of it, there was a spot where the walls were really thick and zig, and it was the end of a corridor, so that if people broke out of their cell, they still had to go like zig between these really narrow walls, and it would definitely slow people down as they tried to slither between the thick walls. So let's exaggerate down and say, okay, we're going to make these walls like really close together, and they were really close together, and that it's longer. In the Toronto jail, it was only like this. Let's say it's 6, 8, 10 feet long, zigzag through a little bit of a maze. And this is a old historical building that's protected by heritage laws and can't be knocked down. And there's no way of getting from this half of the jail to that half of the jail. But you're going to be, you say to people, hey, if you're going to come for a tour of this jail, first off, you have to be this skinny, because we're going to go through there and you can't get stuck between the bricks. And you have to not be afraid of enclosed spaces, because you're going to go through these skinny places. So the people who are going to ride the ride, they know that they have to be so tall and they have to weigh so much, which they can't go on the roller coaster because it's dangerous. And the people who are going to come visit this jail and go see that half of the jail have to know that they have to be able to fit between the skinny place and not be claustrophobic. So you're going to hire the person who does the tours. Do you think it's reasonable? Is it a bona fide occupational requirement that say you have to be able to fit between those bricks? If there's no other way to get to the other side of the bricks and you're doing tours, so we could maybe reasonably accommodate a big person who can't fit through there and say, hey, you only give half the tour and somebody else gives the other half the tour. But does that double the cost for the organization? And does it now make it economically unfeasible for them to give tours of that jail? I don't know. I think that that's the kind of thing that would be taken to court, that they would say it's a bona fide occupational requirement. In other words, they would say people of a certain physical size and shape, which might be considered a disability, or their medical health condition, that they can't have this job if they can't fit through the space. And somebody else is going to say, yeah, but I can do half the tour. Somebody else can do the other half the tour. Or they might say, you can drill a hole in the wall and put a door there, and we can challenge this on the heritage front. These things get complicated. And I'm not saying that they should, I'm not advocating for making it a bona fide occupational requirement. In other words, saying it's legal to not hire people that don't have that physical shape. I'm saying this is how people decide it's unreasonable, if it's unreasonable, economically unfeasible, or just not possible to do these things. And so, you have these other things that happen. For example, when, in the old days, they used to interview sports athletes right in the dressing room after the game. And, men and women are changing, and the cameras, would interview people, but men and women sportscasters would walk into the room, and there'd be men or women athletes in there. And some people said, I feel really uncomfortable with you standing in my dressing room while I'm changing when you're interviewing people there. Why don't you do the interviews out in the hall and ask people to come out? And so, before they would say, we'll only let men into the men's change room. So that they thought was a bona fide occupational requirement, that you would only let men into the men's change room or only let women into the women's change room to do interviews. And they thought it was a bona fide occupational requirement, but then it went to court and they decided, you can pretty reasonably accommodate this. You can ask the athletes to come out into the hallway and interview them in the hall. And then you can have men and women do the interviews. You don't have to worry about whether people have their clothes on or off. And so here's another example of why people get into these court decisions over, is it really a bona fide occupational requirement, or could it be reasonably accommodated? I don't know if those are good examples. Sometimes I give extreme examples to make the point. So here's an example of the dairy case with Mr. Christie, who was employed by, some of these cases are really old because they're the case setting precedents. So it's not like we're using old information. It's like, these are the cases that changed the world. So Mr. Christie was employed by the dairy pool and became a prospective member of the Worldwide Church of God in 1983. And the church recognizes Saturday as their Sabbath and 10 other holy days throughout the year as holy days. And as a member of the church, they're expected to not work on these 10 holy days. So Mr. Christie took a look at the calendar and he realized he was scheduled to work on this rotating schedule, or regular schedule. And he asked his employer for permission to take unpaid leave on Tuesday, March the 29th, and on Monday, April the 4th of 1983. Because these were holy days. And he was granted leave on the Tuesday, the first day, March 29th, but was denied his leave on Monday, April 4th, because, as the dairy pool said, lots of milk comes in here on the weekends and we're closed. And we can't let the milk spoil. So on Mondays, it's all hands on deck. Everybody, we got to have the pasteurizing machinery and so on, all running at full tilt on Mondays from the beginning of the day to the end of the day. And, I don't know why I'm going to make this part up. Let's say they run double shifts. So everybody comes to work on Mondays, and then they run single shifts or shift and a half or something the rest of the days when they're all cut up. But Mondays are don't let the milk spoil day. And so Mr. Christie took his day off, his normal day off. But when the Monday holiday came around, he didn't show up for work, and they fired him. And for willful disobedience. And the Board of Inquiry ruled that Mr. Christie, when he took it to court, was discriminated against because his religious faith had not been accommodated. Now, interestingly enough, and I don't know all the details of this, but I can tell you how it would come about, that the decision was then overturned by the higher court, by the Court of Queen's Bench, and then appealed again and upheld. In other words, the overturning of it was upheld by the Alberta Court of Appeal. So it went to the higher court, Queen's Bench, which is what called the Superior Court in Ontario. And then it went for appeal and went to the appellate court. And so originally they said Mr. Christie was discriminated against, and the higher court said, no, he wasn't. Now, why would that happen? I mean, Was it unreasonable to give the guy the day off? Was the business gonna fail if he didn't work on Mondays? And obviously, the found in the Board of Inquiry, the original decision found that the employer had made no significant effort whatsoever to accommodate his request. In other words, there was no reasonable accommodation. There was no effort, significant effort made to reasonably accommodate it. And so as a result, they were found that they couldn't use working on Monday as a bona fide occupational requirement. But later on, the other court said, nah, this is a reasonable, everybody has to work on Mondays or else the milk goes bad. We can't have people taking Mondays off. And I don't know what facts were brought to the table. I don't know how they made the argument, but the issue is that originally the court thought that they made no effort to accommodate him. And then the other court said, yeah, well, this can't be accommodated. This can't be accommodated. I don't know if that exact case, unless there's something that I don't know, there would, because I think that people would be able to say, hey, we do now operate our processing plants on Sundays, and so we don't have this issue on Mondays. We have enough staff that we can get through this, and we can give them another day off. And everybody's not required. We hire 3 more people, and we got backup staff and temps. We can use temps. I don't know, but in 1983, that one flew the day. So the bona fide occupational requirement principle question raised in this appeal was whether a particular attendance rule imposed by the employer on employee is a bona fide occupational requirement. If it is a bona fide occupational requirement, could the charge of religious discrimination be defended by proving that the employer accommodated the employee up to the point of undue hardship? So that's the issue, right? Did they attempt to accommodate him up to the point of undue hardship? Clearly, in the appeal, they said, we accommodated him by giving him Tuesdays off, but Mondays was an undue hardship. So it was no longer reasonable. So as I said to you, I don't know if that particular case was brought to bear today, whether it would win or lose, but it showed how these cases are to be argued. So here's an interesting one. The CNR versus the Human Rights Commission. In 1985, this one was precedent-setting. The Superior Court of Canada decided that the requirement of wearing a hard hat is not a bona fide occupational requirement and amounted to discrimination on a religious basis. So this entitled a Sikh worker to continue his employment without having to wear a hard hat. So again, is it an undue hardship upon the company to accommodate this Sikh worker who said, look, I need to be religiously accommodated. I can't wear a hard hat. I have to wear my religious headgear, and that's not a hard hat. And the CNR tried to say, no, everybody's got to wear a hard hat. But let's take a look at the Human Rights Commission said, nah, bad argument, CNR. You can accommodate this guy. You can reasonably accommodate this guy's religious needs. So let's take a look at some of the facts on this one. First off, he was a maintenance electrician, and there was no shortage of maintenance electricians. CNR is a big company, big organization. They had lots of maintenance electricians. And so Mr. Binder was not unique and a specialized worker. He wasn't like the only guy who could do the one really important thing. And that one really important thing was really dangerous, with Wile E. Coyote swinging anvils around your head all day long. There was, other jobs that other people could do, and other people could do this job. And so if you wanted Mr. Binder to go work somewhere away from where the Wile E. Coyote swung the anvil around your head, you could easily do that. And you could easily get people with a hard hat to work under the anvil. the employer safety policy would not be jeopardized by Mr. Binder giving an exemption. So in other words, they didn't have to say, oh boy, now we have to give everybody the opportunity to wear a baseball cap. That wasn't the case. They were only saying people for religious reasons were allowed to be exempt from this. Mr. Binder was willing to relocate to a different post in the business where a safety hat was not necessary. There wasn't going to be the anvil swinging around above his head at a different location, though he was not willing to assume duties other than those of a maintenance electrician. So he said, look, I'm not going to become a typist. I'm a maintenance electrician, but I can prove to you there's lots of maintenance jobs around here where I don't have to worry about getting hit in the head. And so don't demote me, don't fire me, don't push me off into the, cleaning toilets. I'm a maintenance guy, and there's lots of jobs that you could assign me to that don't have risk of head injury. Mr. Binder was able to perform effectively and efficiently without his safety helmet. In other words, you might say, hey, you have to wear these goggles that magnify something in order to do the operation, because the only way to do the operation as the doctor is to magnify it. And if the doctor said, I can't wear those goggles for reasons, I'm going to just flounder around in there until I feel the gizzard. Well, they would say, no, that would put people and safety at jeopardy. But in this particular case, he was able to perform his job perfectly well without the helmet on. Neither Mr. Binder's fellow employees nor the general public would be injured by him not wearing it. So, in the case of the doctor wearing the magnifying glasses, the patient would be injured if he didn't wear them. Most likely would be injured. But in this particular case, if Mr. Binder didn't wear his helmet, no harm, no foul to anybody else. And the risk of injury to Mr. Binder, if he did not wear a safety helmet, was really quite negligible. So it seems as though the CNR said, no, we have a safety policy and we're not going to accommodate anybody. Our policy is helmets. Everybody wears a helmet. And Mr. Binder went to the Human Rights Commission and was able to successfully argue that his facts suggested that he could be reasonably accommodated. So which of the following is not a discriminatory practice? Denying someone good services and facilities or accommodation based upon prohibition, of course, that's discriminatory. Denying an employment opportunity based upon a bona fide occupational requirement. Okay. It's a bona fide, a real, tangible, credible, provable, truthful occupational requirement. It's necessary to do the job. So if we deny someone's employment, have we discriminated against them? The answer is no. That is not discrimination. It would only be discrimination if we made no effort to reasonably accommodate that person. And if, in fact, the bona fide occupational requirement was not bona fide. So paying men and women differently when they're doing work of the same value. This is a trick question, because there's nothing in the human rights codes that talks about the value of work. We talked about this yesterday. Who's to measure the value of work? You cannot pay men and women differently if they're doing exactly the same work of exactly the same quality, with exactly the same qualifications and exactly the same tenure. You cannot pay them differently. But we can't say that it has the same value, because you might think that this predominantly female teaching job is exactly the same value as this predominantly male plumber's job. And plumbers are very important, and they're predominantly performed by men, and they get paid X number of dollars an hour. And teachers are I don't know if they are or they aren't anymore, but at one point in time they were predominantly women, and they get paid on this scale. And so you might say they're of equal value. So therefore, the teacher should get, say, the same as the plumber, or the plumber the same as the teacher. But the human rights legislation does not ask us to value work. It asks us to take a look at prohibited grounds and to not discriminate based upon prohibited grounds, which is you have two people doing exactly the same thing with the same qualifications, performing at the same level of service with the same amount of tenure, then men and women should be paid the same. So that's a trick question, because men and women should not be paid differently for doing the same work. But if we're now saying work of the same value, that's the trick part of the question. Retaliating against a person who has filed a complaint with the commission, or against someone who has filed a complaint for them. Remember yesterday? Reprisal. Person has the right to complain under the law. Say, hey, I think that's discrimination. Say, all right, let's have a conversation about this. And if we can find that it's not discrimination, that's fine. Go back to work. If we find that it is discrimination, then we need to accommodate you. But if we say, hey, you made a complaint, we found out that it's not discrimination, but we're going to punish you for asking, reprisal, not allowed. So that is discrimination. Reprisal is considered a form of discrimination. Harassing someone is considered a form of discrimination. Western School District case study number 3. I don't remember this one. In a unanimous decision, the Supreme Court of Canada restored the decision to the BC Council of Human Rights, which found that Mr. Smith was discriminated against by both his employer and his union because of his religious beliefs. So he's found to be discriminated against. Oh yeah, I remember this one. So Mr. Smith was a custodian. He's a Seventh-day Adventist. I'm going to not read all that stuff. I'm going to tell you what I think I remember what happened. So schools rent out the schools to organizations, and they maybe Boy Scouts or Girl Scouts or somebody, or volleyball team or something, or the choir uses the gym, say for example on Friday nights, and they enter in agreements with the school board to rent it or to use it. And the policy of the school board is that there needs to be a custodian on site whenever somebody's in the school. And and so they set a schedule that said he has to be there on Friday nights. But they didn't necessarily always rent out the school on Friday nights. But in order to do that, they set a schedule that somebody has to always be there on Friday nights. And so that way they could always say, okay, on Friday nights, you sweep the floors and you clean the things and you mop the stuff and you wash the windows. And that way we know there's always going to be there. So if we need to rent the school out, we can rent the school out. And from 3 p.m. to 11 p.m. on Fridays. And it just created a flexibility for everyone. They didn't have to say, oh, maybe we can rent it to the choir, but we have to go find a custodian. They just set the schedule that there's always a custodian in the school on Fridays from 3 p.m. to 11 p.m. And the school custodian said, I can't do those. That's, Friday sundown to Saturday morning sunrise. I'm not allowed to work. And so they didn't accommodate him. And the courts came back and said, look, you almost never have groups in your schools on Friday nights, or you don't have them there a lot. And when you do, you got more than one custodian. And if they don't have them there, you can find another custodian. They'll take the shift, and you can clean the floors on Saturday during the day. It's a difference whether you clean it at 11 o'clock on Friday night or Saturday at 11 o'clock in the morning. You can reasonably accommodate this guy. And so they found that he was, so they had this, what started out probably as adverse discrimination, where they had these set schedules of rotating custodians to try to accommodate renting the school out and getting work done and cleaning the floors when people weren't in the school and so on. But then they found out that their adverse discrimination was not reasonably accommodated. They could have reasonably accommodated, which just becomes discrimination. And so they had to revisit. So now it becomes systemic. So now they had to go out and revisit it and change their policy to how they change their schedules and how they schedule people, and their new policy becomes non-discriminatory. Okay, we're not going to spend a whole bunch of time on this. I get confused about this one, but the and we intentionally use confusing examples for you so you can kind of understand the subtleties of it. But Hockey Canada agreed to make changes to protect young players in Ontario from discrimination and harassment based upon players' transgender status. So you guys might remember this one. It was heavily covered in the news. These changes resolved human rights applications filed after facing difficulties at the local arena. And so what was happening was some transgenders in young people who identified as a different gender than that of which they were born with were forced to play in sports, boys and boys groups, girls and girls groups. They were forced to use the same change rooms and so on. And that it went to court, and basically the courts came back and said, and they resolved it. I mean, it was a resolution upon consent, but that the Hockey League would provide training to all of its Ontario trainers and coaches on gender identity and gender expression, so they learned how to use different pronouns and how to accommodate people. And it included training on discrimination and harassment, what not to say, what language not to use, how to accommodate people. And they needed to amend its co-ed dressing room policy, which would be publicly posted for everyone to see and put it on their websites. And include that. A player has a right to use a dressing room that corresponds with the player's self-identified gender. A player shall be addressed by the player's preferred name and referred by the pronoun corresponding to the player's self-identified gender. And a player is entitled to privacy and confidentiality with respect to the player's trans status. Information about the amended policy would be accessible to all staff and to volunteers and to parents and to guardians and to all players. And so basically they said, look, let's come up with a policy with respect to dressing rooms. Let's come up with a policy on how we address people. Let's come up with a policy on how we communicate this information to people. And if everybody lives by the policy, we're good to go. So this is typical. This is the way you want a human rights decision to be decided. You want to hope and believe that people go into these things not knowing, not realizing, that they're not there because of they're mean or they're unfair or they are, xenophobic or something. You don't want to think that there's bad intent. You want to think that people go into these things not realizing, and that through education and awareness that we can fix it, and that people are willing to participate in the fix. And of course, we don't see that a lot in society nowadays. We see some people saying bad things and waving bad flags and saying, and we want to hope that we want to hope that it doesn't happen. And we want to try to make sure that it doesn't happen. And when it does happen, we want to hope that people need just to be informed and that they can come to reasonable conclusions. And that the Human Rights Commission can step in and say, hey, we're going to come up with a way to deal with a policy and training to fix it in the future. And very rarely do they come up with these huge fines. But if you're a bad actor and you knowingly and willingly, intentionally set out to discriminate people, the Human Rights Commission has got the power to penalize you. But that's not the intent. The intent is to make it right. So testing out our knowledge. Let's ask a few questions, and then we're going to move on to the next topic. And 2:30 is our break time, which is in 7 minutes from now. A policy provides benefits to some married couples, but not to others. This may be the case of discrimination based on right-hand side of the screen, family status, and I don't think anybody's talking, so I'm answering it myself. A person is identified, a person is denied a job because of previous conviction for which a pardon has not been granted, or a record has been suspended. So we know what that one is. That is discrimination based upon pardoned convictions. Number 3, an employee has a reaction to dust and chemicals at work and needs to take a couple of days off work. The employee needs the company's address. The employee needs the company's address for the workers' compensation forms to be filled out properly by the doctor, but the supervisor refuses to give it to her. I'm not going to give you my address. How do you not know the company's address? She's told there is no place for her to work at the company because they don't want her filing workplace safety insurance board's claims. Okay. So, that can happen, that people go, boy, this employee is inclined to get hurt or is a complainer, and they filed a workers' compensation complaint, and I don't want them working for us anymore. Well, this is discrimination based upon disability. And, an allergy to dust or a reaction to dust is considered a disability, the same as the reason why we've got policies about people not wearing perfumes to work and so on, because other people need to be reasonably accommodated for their disabilities and their allergies against some of those perfumes. A female employee was an excellent performer and announces that she's pregnant. Immediately, her employer begins to identify performance issues that led to her dismissal. Boy, that's not good. That's a stupid employer. And of course, that is based upon family status again. An employer assigns her employees to weekend shifts without recognition that some employees observe the Sabbath. So of course, that would be, we've gone through 2 or 3 examples of that already. That was a religion. Employer's physical fitness requires based on the capabilities of an average 25-year-old instead of being based upon the actual requirements of the job. So I don't know what the physical attributes of the average 25-year-old are, but so that part is definitely, it's starting to make it sound like it's age. So they say that it's age. It could be disability, it could be age, but it's not based upon the job. Is harassment a form of discrimination? I already told you that. The answer is yes. Okay, so what do we have here? We've got 4 minutes to go. So before we move into harassment, I'm going to give us our 10-minute break, 10 minutes. So we're going to come back at let's come back at 2:40. I'll give you a little more than that. Let's come back at 2:40, 14 minutes, and I will figure out how to stop recording. I'm going to remind everybody, please try to stay online. You can turn your camera off if you have it on right now if you want. Sometimes it's more difficult to disconnect and then try to reconnect again. But we will see you back here. My clock says 2:27 right now. So we're going to be back in 13 minutes at 2:40. And we're going to move into the next area, which is harassment. And I'll figure out in the meantime how to stop recording. See you in 15, 12. Hello, everyone. I think I need to push one more button here. Welcome back. I think I've paused my screen. Give me 1 second. Well, let's find out. There we go. Whoops. No. Bummer. Okay. Now I don't know what you can see and what you can't see. Maybe somebody can come off mute and I will let me know if you can see my screen changing. So now it says, where can harassment occur? Can you see that on your screen? Okay,
Yep.
good. Awesome. Too many buttons to push for an old man. Okay, guys, so we're going to try to be finished well before 4 o'clock today, but we're now on to the issue of harassment. In some of the provinces, particularly in Ontario, they introduced the Workplace Violence and Harassment Protection Act, which became part of workers' compensation, actually, but it's also harassment is covered under harassment is also covered under sorry, my apologies, not workers' compensation, workplace health and safety legislation, but harassment is also covered under the human rights area. So a harassment occurs when someone makes unwelcome remarks or jokes about religion, race, sex, age, disability, or other grounds for the 11 grounds of that are prohibited for discrimination. And this harassment threatens or intimidates you, and it makes unwelcome, or if the person makes unwelcome physical contact with you, such as touching, patting, pinching, punching, so on. So harassment can occur at work. It can harassment can occur out of work. So it doesn't necessarily have to be in the workplace. And there's a time limit to file a harassment complaint under human rights, and that's within 12 months from the last time that the alleged event occurred. So if you go for a long period of time, there's some harassment that you believe is, or someone believes is harassment, and then a year and a half goes by and something happens again, then that event has a clock on it that now starts for 12 months, but the first event is no longer really eligible for a complaint. So the reason why they put these time limits on it, and I think everyone's got various opinions about it, but the reason why they put the time limit on is to say if it's real, you should complain about it. And so it's encouraging people to not let things go on forever, thinking it might go away. So let's take a look at this multiple choice question. I always love these ones. Identify and select the answers below that does not constitute harassment. Discrediting the person by spreading malicious gossip or rumors, ridiculing him or her, humiliating him or her, calling her into question him or her for their convictions. Well, I would say that's harassment. A single or isolated incident, such as an inappropriate remark or having an abrupt manner. Now, by the way, a single event does not usually constitute harassment. Harassment is a recurring set of events or behaviors. However, it has been found that significant single events can be considered harassment. So I would say that threatening to kill someone because of I'm exaggerating. Of course, harassment has a far lower bar than that. But threatening someone because of their religion and telling you hate them because of their religion would probably be considered harassment under one single event. Touching, for example, touching someone's back as you open a door for them, happening once would not likely to be considered harassment, especially if you said, hey, don't touch me, please, and they never touched you again, then that would not be considered harassment. That would be considered poor judgment. And so there's a difference between harassment and poor judgment. So poor judgment that continues on a recurring basis, especially when you say don't do that, is harassment. One event of poor judgment is poor judgment. Unwanted sexual advances that may or may not be accompanied by threats of explicit or implicit promises. So, and that would definitely be considered harassment. A person at work asking another person at work to go out on a date would not be considered harassment. It might be considered inappropriate. It might be considered poor judgment. It might be just wrong. But if the person says no, and please don't ask me again, and then you continue to try to ask the person out on a date, that would be considered harassment. So there's a plural on this with unwanted sexual advancements, which may or not be accompanied by threats. So the threat definitely makes it harassment. The persistent advances, even if they don't come with a threat, would be considered harassment if you say don't do that anymore. And of course, if it comes with promises like I'll give you a raise or I'll fire you, absolutely harassment. Making rude, degrading, or offensive remarks. The answer to that is yes, it's harassment. It becomes questionable if you say to someone, hey, your ideas are stupid. I don't want to listen to you. You always make mistakes. And if I follow your judgment, we're probably going to lose this customer. And you continually say to a person, your customer service with this is bad. I don't respect you. So that might be rude and degrading and offensive, but it also might be true. And those kind of things would be difficult to use in human rights under harassment because they don't seem to be based upon any of the 11 prohibited areas. So if it's because of race, religion, creed, color, place of origin, sex, sexual orientation, marital status, ability, disability, then absolutely, if those remarks were rude or degrading, they would be considered harassment. But if they were just like inappropriate, because you didn't respect the person's decision making, could be considered harassment, but now you start to get into these gray areas. Friendly gestures amongst coworkers, pat on the back. No, not harassment. I already discussed that. But if you say no and it persists, it is. Isolating the person, no longer talking to him or her, denying him or her, ignoring his or her presence, distancing him or her from others. Yeah, of course. So let's take a look at what the machine says. So it says a single isolated incident, such an inappropriate remark or having an abrupt manner, is not considered harassment. Friendly gestures among coworkers, such as pat on the back, one incident, not considered harassment. So I've given you some, back to these. I've given you some examples of how you could make rude, degrading, or offensive remarks become harassment. So those would be considered harassment in most cases, not if it's just an incident, where you said, hey, your presentation sucked. That's rude and offensive. But as soon as you tie it to anything to deal with making a person feel threatened or tied to one of the prohibited grounds, it absolutely is. Okay, so we hear the term quid pro quo. We hear about this very often in politics. And it means this for that. I'll give you something in exchange for something. It's very often used in politics where people make deals, quid pro quo. It's also very often the term is used when there's sexual harassment, where a person basically says, if you date me or do this with me, then I'll give you the promotion. And if you don't, then you won't. And so quid pro quo is very often used in a workplace when a person refuses, repeated requests for dates, or when it has to deal with flirting or subordinates and superiors for romance. But the term quid pro quo doesn't in itself necessarily mean that it's sexual harassment, but it is so quid pro quo doesn't mean sexual harassment, but sexual harassment in exchange for something is quid pro quo, if you can follow the logic on that. Okay, the Act itself states in principle that all individuals in Canada should have an equal opportunity to make for themselves, and this is the quote, the lives they are able and wish to have, and to have their needs accommodated. And so it also goes on to say that the Act is meant to promote this equality by prohibiting discriminatory practices based upon specific attributes such as race, ethnicity, sex, etc., which may hinder or prevent a person from doing so. So we don't need to treat, the act is not intended to force us to treat everyone equal. The act is intended to not treat people badly or unequally because of one of the prohibited grounds. And it is to give them the exact same fair opportunity, not fairness. If you can, so giving two people the same fair opportunity, but then promoting one and not the other because there's only one promotion available, would mean they weren't treated the same. They were just given the same fair opportunity. And so long as we didn't use a discriminatory ground to make our selection, then it was a fair opportunity, but they weren't treated exactly the same. Okay, so let's talk about the principles of diversity, equality, and employment equity. So employment equity, we talked about it the other day. We talked about pay equity the other day, and that it was a law passed by the, that a version of pay equity was passed by the Bob Rae NDP government some 30 years ago. And it was immediately repealed by the Conservative government that came into power after them, because the pay equity was an effort to try to figure out what the value of a job was and comparing it to the value of other jobs and paying people equitably. And it became almost impossible to administer and understand. Even though maybe the concepts are very good, that we should value people for the contributions they make and pay them accordingly. But employment equity is different. And employment equity is, in Canada, a federal legislation that only applies to the federal government employees and to federally regulated industries. There is no provincial employment equity in any of the provinces that I'm aware of. It's certainly not in Ontario and in Alberta. And I don't know of something, which, don't be confused between it and equal pay, that men and women should get paid equally for doing the same job. Employment equity has to deal with taking proactive steps to try to match the distribution of groups, and they identify 4 groups: women, people with disabilities, Aboriginal people, and visible minorities. So we take these 4 groups and we take a look at the community that we live in or we recruit from, and we say, what are the percentages that exist in the community? What percentage are women? What percentage are people with disabilities? And then you ask the question, or you do a study to determine what the percentages are in your workforce, in your company, or in the government, in a federally regulated company or in the government. And when, let's just say, for example, there's, I think there probably is 50%, darn close to 50% men and 50% women in the world and in our communities in Canada. And if our federal government was, say, 75% male and 25% female, our employment equity program would say, oh, it's 50-50 in the community. It's 75-25 in our company. What actions can we take proactively? What programs or things can we do differently so that over time that percentage changes? So these are not targets. They're not goals. They're not mandates. They are not things where they say, oh, we have to hire a person of color, or we have to hire a person of a particular religion or something like that. They're not that. They're measurements that are taken that give you guidance to determine whether or not your workforce is reflecting the community, so that you can take proactive actions to try to remove some of the barriers or introduce some of the incentives to try to make things happen. It doesn't have anything to do with there's 2 candidates left for the job and I have to hire that person under my quota. There's no quotas. You don't have to hire that person to meet my quota. As a matter of fact, employment equity data and information is all confidential. So when a person applies, there's an employment equity program inside a company collects the information and then it's separated from the individual's employee file and put into a database to help give big picture data. It doesn't have anything to do with that candidate or that job or that person. It goes into the big picture data so that we take a look at how is our workforce reflecting, does it reflect the distribution of our community? So the expectation of employment equity means more than treating persons the same way, but also requires special measures and the accommodation of differences. So in other words, what it's saying is that if you've got some differences, you can introduce special measures. You can't say we're only going to run this job in Aboriginal newspapers for the next little while because we ran it in the local newspaper and we got 0 Aboriginal people who applied for this job. So let's run it only in Aboriginal newspapers and post it in Aboriginal friendship centers for the next 2 months to see if we can draw some candidates from that pool too. Now, once they go into the pool and they get evaluated like everybody else. There's no preference given to people. You're not hiring people that are more or less qualified than others. They go into the exact same hiring process, but they may have identified that there's something about the way our recruitment process, we take special measures in order to try to make out the difference. So employment equity is to achieve equality in the workplace so that no person shall be denied employment opportunities or benefits for reasons unrelated to their ability. So to correct the conditions of disadvantaged employment experienced by women, Aboriginal people, persons with disabilities, and members of visible minority, by giving effect to the principles of employment equity means more than treating persons, people, in the same way, but also requires special measures in the accommodation of differences. So employment equity allows you as an employer to take special measures to try to attract people from one of the 4 identified groups to try to help to create a balance. I want you to remember, it does not mean quotas. It does not mean we will only hire people here. It does not mean anybody's ever measured by their success in hiring visible minorities, for example. It is a big picture data collection. So provincially regulated companies, us, are not required to adhere to federal employment equity programs, but we are kind of, sort of, maybe. There's a thing called the Federal Contractors Program. So if you are a supplier, if you're a provincially regulated company like a staffing company, and you are a supplier to the federal government, and you have 100 or more employees, and you've been awarded a federal government contracts of goods or services worth more than $1 million, then the federal government wants you to implement an employment equity program. And so what the federal government has said, hey, look, here's a whole bunch of training modules that we're going to give you and a whole bunch of stuff. And in order to be a federal government supplier, especially companies in the staffing industry, if you're in the staffing industry and you've got 500 employees working at the government and you're making $10 million a year, they don't want to have those statistics excluded from their statistics in their employment equity program. So they require certain employers of a certain size contracts say to willingly say, okay, we will do this. And so they make it a term of the contract. So it's not written into the legislation. It's written as a term of the contract. And they give you versions, English and French versions, of how to implement your program. So if you're a provincially regulated company and you're going to, more federally regulated, but if you're going to introduce the program, you first conduct this workforce analysis. So you go out there and collect your data for the distribution of the 4 groups in the marketplace. You conduct confidential employee surveys. So you ask people to self-identify. Do you fit into any of these groups? You create an employment equity plan. So you take a look at it and say, oh, geez, we got an employment equity distribution issue here. What can we do? Can we change the food in our cafeteria? Can we change the location of the work? Can we change the way we advertise? Can we reduce or change some of the hiring criteria? What can we do that will attract people from these four groups to try to create to match so that our workforce employment matches our workforce, the workforce. We establish and sustain an employment equity program. So now that we put it into place, we announce it, we publish it, we make everybody know what the rules are and how it works. And then once a year, you submit a report to the federal government about what kind of changes you made to your program and what your numbers are like, and you're good to go. Again, it is not about quotas. And lots of temporary companies, staffing companies, and contract suppliers get exempted from participating in the program because they're able to, one, establish that they don't have, they're able to establish that the office that's supplying under the contract is isolated. So let's just say, for example, you're a multinational staffing company and you've got offices all across Canada. You have one office in Ottawa. That one office in Ottawa has a couple of contracts, and you might have 500, 600, 700 temps or employees or full-time staff across the country. But you only have about 5 full-time staff in Ottawa, so you don't come close to 100 there. You might be able to establish that your contractors are independent contractors, so they're not employees, so you don't have 100 employees there. You might be able to establish that even though you've got a contract for $750,000 with the federal government, the other business that you've got for your other $2 million is not with the federal government or not on that contract. So there's lots of ways that companies try, and they do try, to not participate in this program because it is an administrative burden. It's a lot of data collection. And a lot of extra work to collect the data. And so a lot of companies try to exempt themselves from it. Some can't. Some obviously have to comply. They've got no reason to not comply. Some companies just have them in Ottawa or in an office anyways, but they tend to not, if they're national or multi-regional companies, they tend to not run the program in all their offices. They get an exemption from those other offices because they're not supplying the government, and they isolate them to that one particular area. So, multiple choice. Here we are. Employment equity involves all of the following, except identification of systemic barriers to employment opportunities that adversely affect the designated groups, government-imposed quotas. Okay, we know it does not include government-imposed quotas. Plans to overcome employment barriers. Yes, it does. Reasonable accommodation. Being proactive in planning an annual employment equity program. Oh, so it didn't give us the answer to that. So we know that it does not include government imposed quotas. And reasonable accommodation is usually a term that we use to accommodate a systemic practice or a adverse practice. So that means that's sort of event driven. You know, if you've got this reasonable accommodation policy and the policy adheres to, if this happens, then that could be part of your employment equity program. But if you're just reasonably accommodating somebody, that's a deal with discrimination. That's not a deal with employment equity. So if that makes sense to you. Okay, questions for a chat. What are the two major demographic pressures affecting the Canadian labor force today? Large number of baby boomers approaching retirement age, the shortage of young people available to replace them. How do we address these two issues? So these are two issues. That we've got a large number of baby boomers approaching retirement age. There's also some people might say, hey, there's not enough baby boomers retiring, that people are working beyond the age of 60 or 65 now. People are claiming, hey, people are working to the age 60, 65, then they're coming back into the workforce as independent consultants and they're taking up jobs of younger people. Some people are saying that they're retiring early and they're retiring and there's a shortage of people. I mean, these are issues. There are trades. Let's a good example might be masonry trades, where people more traditionally, baby boom age or older Europeans were great at masonry. I don't know, new young graduates, are they pursuing masonry, as a skilled trade that they pursue in their careers? So and then of course we've got a shortage of teachers right now. We've got a shortage of nurses right now. We have a shortage of caregivers right now. We've got certain professions or jobs, like caregivers, are typically performed by recent immigrants and not typically performed by second and third generation Canadians. I mean, there's a lot of moving parts and a lot of things happening that are open for discussion. And as we move forward through these discussions, we also got to ask ourselves, as we're trying to solve these problems, are we unknowingly or unwittingly introducing discriminatory practices? Are we pursuing, if we don't have an employment equity program because we're not federally regulated or we're not under a federal contractors program, are we pursuing practices that are consistent with the values of employment equity, so that we're hiring from across the marketplace to represent the community? So these are all questions that I think that every organization, especially as we discuss the shortages of candidates in the workforce and the difficulty you have filling jobs, that we discuss these kinds of issues and do them always in the context of broadening our awareness of our hiring practices, broadening the scope of the types of people that we attract, and increasing the diversity of our workforce so that we become more effective and more representative to our customers and to potential candidate base. Okay, so here's one for Ontario only. This one's called Accessibility for Ontarians with Disability Act. This is probably one of the best and worst pieces of legislation that could exist. I think it's got the best intentions ever. And I think that all governments, since it was introduced back in, 2010, really has not been supported well by governments. But we're going to talk a little bit about it so that you understand what the OADA is. So the Act speaks of the developing and implementing and enforcing of accessibility standards in order to achieve accessibility for Ontarians with disabilities with respect to goods, services, facilities, accommodation, employment, building structures, and premises. And that the whole thing is supposed to be fully implemented all the way up to premises and structures and buildings. So things like ramps and elevators and, all of that, everything was supposed to be finished with this fifth, I think it was 2010. So it's supposed to be like a 15-year rollout. It might have been before 2010. It was supposed to be like a 15-year rollout to give everybody the opportunity to get up to speed. And so they set multiple milestones along the way. The first milestone was an easy one. This was customer service. This 2005. So there we go. So it was a 20-year rollout. So in 2005, they introduced, and they said, okay, the first step is customer service. We need to make sure that everybody who works in your organization understands how to communicate with, provide information to, make it available publicly on your websites, but tell people what language to use, teach people how to deal with people with disabilities. And then we needed to introduce this information and communication. So it's creating documents, creating training programs. And then it was to open up our employment to people, to try to get a more diverse employment workplace with people with disabilities. The fourth stage, which is an interesting one, and I'll tell you a quick little story about this one, had to deal with transportation. This mostly had to do with public transportation, our buses, subways, and so on, and rapid trains. That needed to be fully accessible to people with disabilities. And then finally, this, as I mentioned to you, by 2025, the built environment, ramps, stairs, elevators, lifts, windows, lighting, width of halls, height of tables, the whole deal. So the transportation one was an interesting one. So I might have mentioned to you, I have a 27-year-old daughter. She's severely disabled. She's in a wheelchair, and she's never walked. And we have a van, the lift seats, and so on and so forth. And our whole house is wheelchair accessible. And she is approved for Trans Help, which is Wheel-Trans. So it's the public transportation system where you pay $5 and whatever per trip, and you can book it in advance. And instead of going to the public transportation buses, the bus will come to your house and pick you up and take you to your appointment, and then pick you up and bring you back. It's not the best. But my God, it's awesome. Like, think about the money and the time and the effort and the resources that are put into this, and so it has its challenges and its implementation and so on. It's not perfect for everyone. But because of this transportation thing, in stage 4 of the OADA, cities and municipalities were required to make all their public transportation accessible. So they started to introduce wheelchair accessible buses that I call leaners. These are buses, when they come up to the bus stop, they stop, and then if someone's there with a wheelchair or with a walker, it goes down and hydraulically down. Then sometimes it tips a little bit, and then this ramp comes out, and I'm making all the sound effects. And then the person with the walker or the wheelchair can roll onto the ramp, and up they go. And then there's supposed to be spots they can click into in the bus. And so they're supposed to make this accessible to people in walkers and wheelchairs and canes and prosthetics and other assistive devices and disabilities. And so what this meant was that when they introduced in my city, in Mississauga, when they introduced these buses, they came along and said to Samantha, "You're no longer eligible for Wheel-Trans Help to come to your house because we've now made the entire public transit system available to people with disabilities," which is sort of kind of true, except for it's 1.5 kilometers to the closest bus stop. And there are no sidewalks in my neighborhood. There are these huge ditches without sidewalks. And because we're not on a main thoroughfare during snowstorms, we're the last people to ever get snow removed in our neighborhood. It can take 4, 5, 6, 7 days to have a thing come through here, a snowplow come through our neighborhoods after a snowstorm. And so here we have these old, it's a 190-year-old neighborhood with original narrow streets with big culverts and no sidewalks, and there's snow and rain, and it's 1.5 kilometers away. And we're like, okay, you just killed swimming lessons for us. And you just killed, because while I'm at work, her caregiver might take her to swimming lessons, or might take her to go to a wheelchair program at the gym where she's going to play a wheelchair sport or something, or go exercise, or go visit someone, go to the, whatever. They can't, especially from about October 15th to May 15th, they can't get there. Her hands would freeze. She can't roll in a manual wheelchair along frozen ground and not freeze her hands off. And so, the greatest intentions were set forward with the OADA in 2005. And many municipalities and businesses have made great strides. The enforcement of it has been very slow and very poor. And I think lots of organizations are going to miss their built environment stage 5 just because of the absolute cost associated with putting in elevators where there used to be stairs and so on and so forth. But your organization should have an OAD, if you're in Ontario, an OADA plan. You should have a workbook. You should have something on your websites. You should have a strategy and a policy written out, like what happens if your elevator is broken, how do people access your office? There should be, things like that. And so it's kind of, I encourage people to go and take a look at the OADA. So 1 in 7 Ontarians has a disability. 95% of disabilities are considered to be hidden, so we wouldn't immediately identify them in an interview or on the spot. It's estimated that 1 in 5 Ontarians will be 65 or older by so 20% of our population is going to be 65 or older by 2025. So that issue I talked about earlier, half of that group will have some form of disability. By the way, once you got to wear glasses beyond a certain strength, it's considered a disability. If you don't hear perfectly and if you need an aid, it's considered a disability. Dexterity, mobility, back pain, these are all considered disabilities. So they don't have to be, in some of the more commonly sort of characteristic type of disabilities like Down syndrome or, an amputee or something. There disabilities come in all forms. And the important thing for us to recognize is that we don't see them. We don't recognize them. We don't know. We don't know why a person doesn't perform well on the job. We don't know why a person really is absent. We don't know how a person feels and how it affects them mentally. Mental health issues are a disability. And we don't know how these things, and now this is me, going off topic, on topic, off topic. What we're seeing, and I think it's exposed itself, during pandemic. Well, people are protesting and people agree with mandates and people disagree with mandates, and people agree with vaccinations, people disagree with vaccinations, people agree and want masks and are afraid to go in public and around people and, with who don't have masks on, and other people are bold and obnoxious and my right, my face, my mask kind of thing. And, then we see truck drivers who have mixed messages and not truck drivers pretending to be alongside of truck drivers with a whole variety of arguments. And we have become so brazen in the way that we communicate with each other. We have become so harsh and, need to say sometimes very mean in the way that we try to communicate our vision or our values or our beliefs. And the important thing I think for us to remember is that we don't know. Like, maybe if you knew everything about everybody, maybe if we knew everything about everybody, then we would know exactly what we should say or what argument we could use or try to convince people of things. But the fact of the matter is 95% of the people in this province, in this country, have some form of hidden disability. And we don't know why they believe, and then of course we don't know what their religion is, and we don't know what their heritage is and what their culture is. We don't know. And even if we think we know, we're probably making assumptions that may not be correct. And so I think that we want to tone it down a bit, take a step back a bit. And instead of asking ourselves, why am I so angry about what makes us different? I really like to take it like I'm an entrepreneur, I'm a business guy. I like to look at it and say, what opportunity exists here? How do I expand my candidate base? How do I attract more better people? How do I do business with customers that maybe I didn't really understand before? How do I get a more diverse customer base and a more diverse candidate base and a more diverse group of employees and coworkers? How can I leverage that to become more profitable? Because when I'm profitable, I create meaningful employment for people. I create decent work and income, and other people are happy. And then they look after their children and they look after their families, and they become less stressed and they become less argumentative and we become less fractioned. And so we've taken on, and I think it's always been there, but I think that during pandemic, it's become super exposed. That people have decided it's winner take all instead of how do we take the opportunity for us to remove barriers of discrimination, to take the differences we have in beliefs and to leverage that so that we all become better. Now, I don't mean support knowingly bad people or something like that. That's different, right? But I'm just talking about the general discourse that's occurring in our economy. And I think that legislation like employment equity and legislation like human rights and legislation like the Charter of Rights and Freedoms and legislation like the Ontario Accessibility for Disabilities Act are all intended to sort of help us try to move in the right direction, not dig ourselves in the wrong place. So a disability by the AODA includes a degree of physical disabilities, infirmities, malformations, and disconfigurations conditions of mental impairment, developmental disabilities, learning disabilities, mental disorders, injury or disability, which is a benefit for a claim under workers' compensation, is considered a disability. Disabilities may be visible, they may be invisible, they may be continuous, they may be intermittent, they may be temporary, they may be short-lived. They can vary in severity. It's not up for us to say this person's not disabled enough in order for it to apply. It's not for us to say, we will only hire people without disabilities. It's our responsibility to accommodate them and to make our workplace accessible. And it's not up to us to say, oh, I don't need to accommodate this person because that's not enough of a disability. Get over that. That's not what this legislation is about. That's not what I don't think what Canadian culture is about. And that's certainly not if you want to be a successful recruiter and staffing company in the staffing industry, an attitude that's going to help you get very far in life. An organization is committed to providing exceptional, accessible. So here's a sample, by the way, of a policy. Every company has to have a policy. If you don't have a policy written someplace, take this one, change it to put your name in it. But the organization is committed to providing exceptional and accessible services for our customers, and you could put in our candidates, and our employees. Our services will be provided in a manner that respects the dignity and independence of all customers, candidates, and employees. The provision of services to persons with disabilities will be integrated whenever possible. So that's the reasonable part, whenever it's possible. Persons with disabilities will be given an opportunity equal to that given to others. So we're going to have an elevator over here, an escalator over here, and some stairs over there. We're going to give everybody an opportunity to get upstairs into our office to obtain or to use and benefit from the services provided by and on behalf of our organization. So the first thing that an organization needs to do under AODA is to have their senior executive enter into a written and signed policy that they can make available to everyone. So accessible training, accessible devices, service animals, temporary disruptions, a feedback process when people are complaining. How does that work? And having all of your documents available in formats available for people, say, for example, for Braille or in audio format or something like that. So, hey, listen, we've all failed at this. I can tell you my companies do not have everything available in Braille and audio format. Although I think that you could, most people can probably have a device on their computer and take any document that comes from my company and then have it read it for them out loud, because they're done in text-based PDF or in Word format. So there you go. Diversity. I've gone down. I've given you my speech. I've gone down. Employers in all sectors of the Canadian economy are now more than ever focused on attracting and retaining a diverse workforce. It's really important. If you want to be successful, you gotta have a diverse workforce. I was saying this in 1985. Probably the first public presentation I did to our industry was around 1985 or 86 at a place up at Yonge and Eglinton. And, I think people might have thought back then I had my head screwed on sideways when I was trying to tell people in that presentation at this venue that ACSESS booked in 1985 about how important it was to our profitability and our future to become more diverse, and that we did not want to become the vehicles that discriminatory clients used in order to accomplish their unsavory goals and objectives. That we needed to set the standard, that our industry could make a change. That whereas companies might have discriminated before when they were dealing directly with candidates, but now that they're dealing more and more and more with us, we have the opportunity to raise the bar in the middle, to remove the barriers, to create the accommodations, to change the manner in which we do things. And so, and I still believe that. And I believe that my businesses were successful, and most businesses that are successful is because they adopt those kinds of philosophies and policies. So we talked about human rights legislation today. We talked about employment standards legislation the other day, employment equity legislation federally. We talked about today, and the Employment Equity Federal Contractors Program. And now I've just given you a little bit on the AODA. And for the next 10 or 15 minutes, we're going to talk about privacy, and then we're done for the day. So several years ago, and as a result of the Charter of Rights and Freedoms. Certain privacies and protections were written right into the charter. And so the federal government introduced PIPEDA legislation, which is Personal Information Protection and Electronics Documents Act. And then each of the provinces was given the opportunity to either say, yeah, okay, I'll use that one. We'll just take it and use it, or to write their own. And almost all provinces almost immediately went about creating their own version. And the reason why they wanted to create their own version is because things like penalties and process and who you complain to and all that kind of stuff really had to deal with the various commissions and councils and so on. So they couldn't just use the federal government legislation exactly as it was. But of course, some of the territories and so on did use it. I think maybe Nunavut uses it still. But each of the provinces came up with their own PIPEDA or privacy legislation. And so you'll very often see privacy statements on people's websites saying, you know, what they have access to and so on and so forth. But there's some real basic principles to how the Act applies. It applies to private sector organizations across Canada that collect, use, or disclose personal information in the course of commercial activity. The law defines a commercial activity as any particular transaction, act, or conduct, or any regular course of conduct that is of a commercial character, including the selling, bartering, or leasing of donor memberships and other fundraising lists. So this applies to anybody creating lists, customer databases, you know, keeping information. And so the provincial laws, Alberta, British Columbia, and Quebec have their own privacy laws that are substantially similar to PIPEDA. The federal government has their. Ontario, New Brunswick, and Nova Scotia, Newfoundland, Labrador have adopted substantially similar legislation regarding the collection and use of personal health information. So in Ontario, for example, you know, this additional personal health information thing became sort of the predominant focus on the way the legislation was modified. So the 10 principles of PIPEDA are that there's accountability to the people who are collecting the information. They're responsible for everything they do with it and why they collect it. We have to identify, number 2, why we're collecting it, and tell people that we're collecting this information for this purpose and promise them, and it will only be used for this purpose. So like the old days where people used to maybe get people to fill out a survey and then sell that information to a credit card company, nah, no good anymore. When you collect personal private information from people, and particularly in some of the provinces like Ontario, health information, it's really important that it's only used for the purposes of which it's being used. So let's go into modern vaccine passports. So when you go to show your vaccine passport in the province of Ontario and they scan your barcode, it says your name, yes or no. That's it. That's it. It doesn't say when you got it, who your doctor was, what your health number is. That's what the whole purpose of that thing was. It was to say, this is mine. I've used my health number to get this thing. It's going to say it's for Steve Jones. And yep, he cut the grade. He's got his vaccines. And so they collected a whole ton of information. What vaccines we got, where we got it, what dates we got it on, you know, what our health numbers were, what our address is, you know, all that kind of stuff. But in order to protect people from showing all that personal information, they came up with a system that made the government accountable for only disclosing the information and using the information for the purpose it was used for. So all that other information was hidden. So we have to ask people for consent to collect the information and to use the information. We have to limit the collection of it to just the purpose it was intended. Limiting use, disclosure, and retention. So we have to tell people what's in there, and we have to promise them that we will only keep it for a certain period of time or for that use. We have to make sure that it's accurate. We have to make sure that there are safeguards to protect it so people can't steal it. So a big thing in the health world is like, what happens if a traveling nurse who's doing community home care is going from place to place to place, and she's got her, he or she has their iPad or tablet with them with all these health records, and then they accidentally leave their tablet in McDonald's. Well, man, each company has got like a whole series of protocol on who you have to notify, how quickly you have to notify them, what patients have to be notified, what the process is to shut it down, to burn it, to make it explode, or whatever it is. So there's, there have to be safeguards and processes, and there has to be an openness with respect to that information. When we think about these websites that have been cracked into and somebody's violated their security and got access to the database, so we need to disclose that to the public right away. So an individual is supposed to be able to look into their own file and determine whether the information is accurate, and they need to be a process for challenging compliance with the program. So what would be considered personal? Oops. All of these things: age, name, ID numbers, SIN, social insurance numbers, ethnic origin, blood types, religion, your opinions, your evaluations, your comments, your social status, disciplinary actions at work, employee files, credit records, loan records, medical records. All of these things are considered private. Now, if you're in the executive search business, imagine, like, I don't even want to think about what's going to happen if you're in the executive search business. I mean, and trust me, I know the executive search business real well, but what I'm saying is I don't really know what to think about how we even handle PEPITA, because executive search consultants get on the phone and they call you and they say, hey, my name's Steve and I'm an executive search guy, and I'm working on this thing and I really wanted to talk to somebody like you. And, you got a couple of minutes, can I talk to you? Yeah. And then during the conversation, how long you worked there for? And, where did you go to school? And what is your thing? And, what kind of projects have you worked on? And then eventually, how much money do you make? And how much money do you want to make? And how much money would it take for you to move someplace else? And do you know somebody? And can I get your email address? And can I get your phone number? Can I call? Is this your cell phone? Can I get your cell phone number so I can call you back? And we build these catalogs of information that we get by having conversations with people who we earn their trust. And we collect and create profiles on people. And then a mandate comes in from our customer and we go, I got that person who used to work for the Ontario Securities Commission who always told me they wanted to go into private sector for the last 10 years of their life. Where's their phone number? And you find them, and you've probably got an applicant tracking system or an ATS or some sort of resume tracking system, or something that's online that you have no idea in the cloud whether your supplier really protects that information or not. And you're sharing information on LinkedIn, or you put it into LinkedIn in your corporate LinkedIn profile. And, who knows, can people break into that and steal it? And does your coworker have your password and return your 3x5 card? In the old days, it was the Rolodex. Did we tell the customer the reason we were collecting that information? Did we ask for their permission to write it down? Did we ask for their permission? Can we call you someday? Consider you someday? No, executive search consultants just have conversations and go deeper and deeper and document everything in a retrievable fashion. And so when you think about it, how does this even affect the industry? What are they really allowed to do or not to do? And of course, nobody's going to complain until and unless you sell the database or you just annoy the darn out of them, but you typically don't see complaints about this kind of stuff. You typically see complaints about people who've collected information because you bought something online or you registered for something and then the database got broken into and stolen. But, the reality is that privacy of information concerning things like your health status and whether or not you've been exempt from getting a vaccine are your own personal private information, and it should not be used in hiring or sharing or giving to other people. And so So our industry has some challenges around that, right? And your company should have a privacy policy that's available for people at least to understand that why you're collecting the information and what you use the information for. One of these things doesn't belong. We're almost at the end. One of these following statements about consent is false. Organizations can generally rely on implied consent when the information is likely to be considered sensitive. The consent mechanism chosen should be clear and unambiguous. Consent can be obtained in a number of different ways. Consent can be obtained in a number of different ways. You can ask somebody, you've probably been on a phone call before. We say, I need to get your consent for this. I'm going to ask you some questions. Would you please answer yes or no? They're recording and or they're documenting the fact that they ask it and you can't avoid the question. Yeah, I got to say yes or no. They can send you a form. You can fill it and send it back. You can go online and click a box. Organizations cannot generally reply on implied consent that they will give you information and allow you to use it. And one of the even more poignant comments about implied consent is that this negative implied consent, I don't know if that's what they call it, send us the form by Friday. If not, we'll assume that we can use last year's information. So this is sort of negative. Do nothing, and you're saying yes. Well, most people do nothing because they do nothing. They do nothing because they're busy, because they're lazy, because they didn't read it, because they can't keep track of their emails. Most people do nothing for a reason other than wanting to intentionally send you a message that they're doing nothing. And so implied consent is generally not an accepted. You can use implied consent, if it's like 2 people or something, but certainly not for 200. So there's a process for making a complaint. The complaint goes to the privacy officer of the organization, and the privacy officer should resolve it. If it's not dealt with by the privacy officer of the company and they don't resolve it, or you feel like it has been not handled satisfactorily, then you go to the Privacy Commissioner of Canada and you make an application for your complaint, and then they intervene and try to resolve it. The last thing that privacy commissioners want to do is start taking people to court and fine them, because usually it's got to do with a mistake or an error or omission or somebody not understanding, lack of information. It's usually not, although it could be, it's usually not somebody tricking you into giving you information and then selling it to somebody else. And if that was the case, then of course it would go towards criminal courts. We've got some issues around social media. We could talk about this all day. Keep in mind that you may be violating a person's privacy if you start to, what is the right word? If you are going to be searching through their social media posts and trying to develop some kind of profile on them, and particularly if you're developing a profile and collecting information on them about things about prohibited grounds, and then using that in your hiring or in your promotion of people. So social media is really important. I only have one, we could talk forever about it. I only have one piece of advice around social media, and that is develop a social media policy. Have a policy that says when you're at work, you're allowed to do this or not allowed to do that. When you're using company computers, you're allowed to do this, you're not allowed to do that. If you do something at work that is on our computers or in at work, we have access to use it. When you're here, you must follow these guidelines about honesty and integrity and confidentiality and all of that kind of stuff. So develop a social media policy, think about it, get a lot of people involved, write it, have people challenge it. But in the absence of a social media policy, it's the wild, wild west. Anything can happen. Now, some policies are better than others. I've written some that I think are pretty good. I've helped some companies write some that I think suck. I've seen some that are so overzealous, there's no way they could ever be enforced or enforceable. I've seen some that are just, not good enough. But keep in mind, as a recruiting business, you probably do want to be encouraging your recruitment consultants to be posting stuff on LinkedIn and posting jobs through Facebook and advancing the message from your company about what you're recruiting for on Twitter. And you may you may not be having them use separate social media accounts in order for them to do that. You may be trying to leverage their reputation and personality and personal contacts to help them promote themselves in the business. And so it gets messy. But understand that there are issues around human rights, and there are issues around privacy protection, and there's issues around confidentiality and non-competition that we talked about also, that should be taken into consideration while you develop this. Okay, so look at me. I promised to be finished 15 minutes early, and we are 17 minutes early. I really don't mind staying on the line and talking to some of you guys about, I really don't mind talking to you guys about some of this, and particularly if you want to delve into social media. I'm perfectly willing to do that. So if you want to, you can type in questions, or you can take yourself off mute and just jump in there and ask a question. All right. Okay, so talk about the negative consent. I'm going to assume that if you don't say anything, I was awesome. So by you saying nothing, you're giving negative consent for my awesomeness. How's that work out? See, it's not fair, is it? Okay, anyone there? Oh, I see. I got a thumbs up from Jody. Thank you very much. Or maybe that's your profile. I don't know. Anyone, any other questions? And by all means, you can expand your questioning into other areas. No. Okay. No. Awesome. Okay, guys. Thank you very much for joining me today. I can't tell you, I don't have it in front of me when the next session is, but I'm sure it's coming up soon. I want to, before we go, just promote one little thing. And I'll say this. I've told you before, I've been in this business since 1983. I've built businesses up to $400 million in revenue, and 400 or 500 desks across the country, thousands and thousands of jobs filled per year. And I own some similar staffing companies now, and certainly have consulted with hundreds and hundreds of staffing companies. And I learned pretty much everything that I know about staffing from other people in the staffing industry. I learned it in the beginning from people that were running businesses in the Toronto chapter, and they'd been around for 10 or 15 or 20 or 30 years before I joined. And I made great friends with Bill Koch, who was the Canadian founder of Manpower Services in Canada. And he took me under his wing. I didn't work for him. He just took me under his wing, and he taught me things and became a mentor to me. I went to I think I've been to every live access conference ever in Canada. Maybe one, I might have missed one. I don't think I did though. I've been to every access conference. I've been to dozens, if not, I don't know how many US conferences and other provincial chapter conferences, but pretty much everything that I know about staffing, I learned from somebody in the staffing industry, or at a staffing, or a speaker at a staffing industry conference. I learned from people who came to work with me and for me, and business partners who joined with me. There isn't a university course that says, hey, I'm going to take Canadian staffing in my honors fourth year at university. There isn't a human resources course that even ventures into third-party recruiting, except for maybe to say inaccurate and bad things about our industry. If you're going to be taking an HR course at one of the universities or colleges, you learn this from us, from your peers, from the CPC, from your coworkers, from your owners and managers, from your business partners, and at conferences. It's been a challenge during COVID to have conferences live, so we haven't. This year, in the month of May, ACSESS will hold either a live or a virtual conference. As a member, employee, or owner of a member company, you have got the ability to attend those conferences and to attend at the member rate. And I think non-members can attend and can attend some of those sessions, but they pay a significant premium. Keep your eye open for information that comes from ACSESS about the upcoming conference in May. Don't miss it. I mean, it's inexpensive. It's filled with the kind of information we need. It's the only place you're going to get speakers who are going to be talking specifically about recruitment, about search, about temporary help, about contract, about the legislation, about the rules, about the best practices that exist for our industry. So if you're not already registered on the ACSESS website as a user, then go onto the ACSESS website. See, I can't remember if you can register online or whether you have to send an email to Jennifer at the ACSESS office to set you up and give you a password. But do that, because you'll also get information there when it starts to open up again about chapter meetings in your region. Get out and participate in those chapter meetings, participate with your chapters. This is the place where we learn. This is the place we get better. And just by virtue of the fact that you've signed up for your CPC, I know that's what you want to do. So until the next time, thank you very, very much for joining me again today. Today, we got to talk about some things that I believe wholeheartedly in, with human rights, openness, equity, and how it can affect your business in a positive way. Take advantage of it. Good luck, everybody. Talk to you again real soon.
Steve. Thank you, Steve.
Thanks.
Thank you
Bye.
for everything.
Thanks.
Thank you.
Bye-bye.
Thank you. Bye-bye.
Thank you, Steve.
Thank you.